My lady, my lords, I was in my printed case at paragraph 133, page 224, and I was saying that Article 26 establishes the precise opposite of that which my learned friend would seek to establish, namely that there is no roaming right in the refugee in an overseas territory to go everywhere within the territory unless aliens generally in the same circumstances can do so. The respondents are in an extraordinary position, which means that the qualification in Article 26 does not apply. There aren't aliens generally in the same circumstances. And both the Court of Appeal at paragraph 82, page 359, recognised that, and Mr. Justice Foskett also thought the same at paragraph 303 at page 444H. It would be absurd, we say, if Article 26 could be relied upon by the UK as a reason why the respondents couldn't travel to the UK. Refugees Convention, we say, should not be construed so as to make those such as the respondents in territories such as the SPA's third-class refugees. The third preliminary point is that it follows from the above that it is only where the contracting state can't satisfy its obligations in an overseas territory to which the Refugee Convention has been extended that there is there is a duty to respond, to do something, to choose another territory where it can do so, its territory, the state's territory, and permitting the lawfully present refugee to move there. And again, as the Court of Appeal noted, it's clearly possible for the Secretary of State to permit the respondent's entry to the UK and also to other BOTs, none having been identified. That is consistent with Article 32 because there's no expulsion from the territory. Territory means metropolitan and extended. If you transfer a refugee to another part of your overseas territory or to the metropolitan territory, that is not an expulsion from the territory. And moreover, it's a transfer from one territory where you can't meet your obligations to another where you can. I'm not going to address you on the pull factor. You've heard no argument about it. Our arguments, our submissions are set out.
What is the passage on 444H which you say helps?
He says that Article 26 doesn't give you the right unless the Refugee Convention obligations can't be...
I'm not quite sure I do read it necessarily like that.
Well,
Maybe that's what he meant. You'd have to...
You have my submissions of principle. Article 26 blocks the refugee roaming around the world unless other aliens can do that. It's a block.
But if an alien is present in an SPA, this is a different point. You don't suggest they can come to the UK, do you? Or do
No,
you?
of course not.
No.
There's immigration control. BOTCs can't come to the UK. There's immigration control, never mind aliens. Cypriot nationals can't just come here. If they can't, nor can we. Cypriot nationals can't go to the Cayman Islands, just hop on a plane and go there. Cayman have their own immigration ordinance. How is it possibly suggested that somehow a consequence of my case is that the refugee can just roam around everywhere? It's obviously very theatrical to say that. It's got absolutely nothing to do with our case, Article 26, or the particular circumstances of these respondents. Then I now want to move, please, to Mr. Justice Foskett's judgment. Before I do that, can I just show you one paragraph in the SFI at page 125? Sorry to keep going back to housing, but here you have an agreed fact, paragraph 26, page 125. Here you have an agreed fact that the accommodation due to be demolished in 1999 is no longer regarded as truly habitable, and there's an urgent need for a move of location to take place. there are health concerns raised by the fact that asbestos is in potentially harmful quantities and form has been discovered in all of the accommodation. Those are judges' findings, and there's no challenge to them. There wasn't any challenge. There couldn't be a challenge, and they are agreed. And then, if I can then run you through, as quickly as possible, the judgment at first instance. And with reference to, you just have an eye on our paragraph 141 in our printer's case, 227. But if I can start at 340, which is at 454. So here, Mr. Justice Foskett says, as I've already indicated, see the paragraphs above, it is common ground that the UK can't in practice provide the claimants with their full convention rights within the SBAs. The only way in which those rights can be secured in full is either by an arrangement with another country, the obvious candidate being the ROC, or by permitting the claimants entry to mainland UK. So he's saying the only option is go to Republic or go to the UK. And this is in circumstances where there was evidence and argument about this second option, namely stay in the SBAs, query where, and rely on the Republic.
I mean, when he says the only way is by an arrangement with another country, being the ROC,
Yes.
that may well be the only cost-effective way, but in principle, the British government could build housing for them. It could provide schooling for them, and no doubt it would be a very expensive thing to do, and I don't suppose they wish to do it, but,
Yes.
but it's not actually right to say that it isn't possible.
Well, I think on the facts, he's not, having reviewed the position as it's been for 17 years or so at that point, he's drawing a conclusion in light of the inherent limitations of the SBAs, and there is the Article 34 point, of course, as well. But if I can go back, please, to paragraph 76, which he refers to. So paragraph 76 is at 385. He's referring to a December 1999 letter from the MOD to the Home Office. If you have that, letter E, we've exhausted all the options that we thought were open to us. Refugees are the responsibility of the UK government, but we have no means of discharging that responsibility while they remain in the SBAs. So that's very clear. Sorry, yes, 1999, yes, of course. And against letter G, the MOD administration, the SBAs, has no such facilities. We cannot, because of our treaty obligations, which obviously continue, accommodate refugees on any sort of permanent basis.
Well, that was written 4 years before the MOU.
Yes.
Which on the face of it accepts that your clients can remain in the SBA,
Yes,
among other things.
I'll show you the MOU in due course. The MOU is actually predicated on a commitment to uphold Appendix O. So even if there is a small micro-society of these people, there is going to be no society for the purposes of Article 34. equally, that doesn't begin to answer the right to naturalisation. Mr. Eady's point is, well, you can try to get Cypriot nationality. That is hardly a discharge of your obligation under Article 34 to facilitate, as far as possible, naturalisation and to expedite it. You don't meet that obligation by saying you can have the nationality of Russia.
Well, it may
You don't like the individual, or it's a problem for you.
It may be that it's not possible. I mean, the premise of Article 34 is
Graal
that it is.
Madsden and Professor Hathaway say the one thing that you cannot do is say it's not possible out of an unwillingness. For the SBAs, there is an inability, but for the UK, there is an unwillingness, as the Court of Appeal correctly found. I'll show you Graal Madsden. I'll show you Graal Madsden and Hathaway in a moment. It is possible. The only reason it's not possible is because the UK won't let them in here. And then, my lord, my lady, at 83, new settlement is prohibited, etc. Letter D in 2001. Over the page, bottom of the page, 86. A solution needs to be found given that the asylum seekers can't remain on the SBAs indefinitely. 92, at page 389, between D and E. It appears that the UK representatives emphasised it wasn't possible for the UK, within the context of the SBAs, to afford the refugees the benefits, employment, education they'd get elsewhere. This is in 2009. 96, this is the other paragraph to which, 96 is the bottom of the page, other paragraph to which Mr. Justice Foskett referred, 340. This is in 2002. It's worth a letter from the administration of the SBAs to the MOD, focus in some direct language on the problems, on the key issues. It's worth reiterating why the status quo is unacceptable. Critical issue is the inability of the SBA administration to support the UK's commitment to delivering the refugees. That gets it right. The UK's commitment. This stems from three factors. There's no SBA society or economy into which the administration can integrate the refugees. Secondly, the SBA simply doesn't have the executive arms or resources which a normal civil government would be able to bring to bear on this problem. Legal and treaty framework within the SBAs operate because of the prohibition on settlement. And paragraph 5 against letter G, overall problems are not surmountable. The only viable long-term solution must be either integration into Cypriot society, which means their recognition and acceptance by the public, or resettlement off the island. And we say this makes it abundantly clear that the Secretary of State, the UK, could not comply with refugee convention obligations in the SBAs. Can I just take you briefly to 122, which is at 397. It is said against us that what's reviewed in 122 and 123, this is not carrot and stick, because the words carrot and stick are not used here. That said, in Mr. Eady's reply, paragraphs 32, 33, 35, and at 38, where they say the claimants rely on the memorandum of 23rd September 2005, around this time, as evidence of a characteristics policy. The term characteristics is nowhere used. So it's not used. We'll accept that. Perhaps I can just say pressure. So you're closing here, medical services, playground, health visitor, and across the page, paragraph 126, you're not fixing the sewers or the water supply. So, okay, it's not carrot and stick. We'll just be content with pressure to leave. The next paragraph I can take you to, please, is 138, at page 401. And so this shows you that remaining in the SPAs outside Richmond Village is there. It is there. And when the judge says you can't do it, he is also contemplating that, not least because there is a where question. And we have that 401 led between C to D. This is the UNHCR clarifying their view that the right to opt to stay applies to the SPAs in general and not the Richmond Village in particular. At the bottom of that quotation, against just above E, UNHCR don't support the transfer of their papers without consent, as their legal status is clear. And then at 146, this is very important, on this move elsewhere, internal relocation, if you like, option. James Gondel, a minute from 2009, this is asbestos, potentially harmful qualities. You will be glad to know I'm not making that point yet again. But here we have letter E. Sorry, can I start from D? While some of this may be attributed to the general state of disrepair of the accommodation, it's possible to say this may have been worsened as a result of action taken by the administration in January 2008 to render a number of empty houses uninhabitable. The action was taken to prevent further individuals joining Richmond Village, so integration, and to deny those who had left the ability to return. This work involved the rough removal of door window frames. Although temporary alternative accommodation has been offered, the current occupants of the village refused to leave to allow the necessary work to take place to render the site safe. You'll recall from the Hesu case, paragraph 91, the judge regarded the alternative accommodation in that case as akin to a detention camp. We have therefore only been able to erect temporary fencing to restrict access to the worst affected areas. If the administration is left with an ongoing responsibility for these families, alternative accommodation will have to be found. This is 8 years ago. Due to the military nature of the SPAs, there is no rental accommodation available, and the option of using empty married quarters, all of which are now in close proximity to other service quarters, which presents unacceptable security constraints. The SPA has identified only one viable option for alternative accommodation, which would be the erection of mobile homes, costs approximately £500,000. And never has it been said, so Hickman reminds me in defence of this claim, oh, well, we will spend £500,000 on building some proper accommodation for you. It could be done. Many things could be done. It's not, you'd be totally wrong with our respectful submission to base a decision on the idea that that could somehow be done these years later, when there's not a scintilla of evidence that there's any willingness to do so. You have my point. Supervening impossibility of performance, even if it applied, it doesn't, because the UK is a contracting state, is not made out because of want of resources. And then 153 to 55, again, carrot and stick, December 2009. This is where there's official authorization of the carrot and stick approach. 155, page 405, letter D. And then we need to, if we jump forward now again to 340, you'll see that that conclusion is reached, that given Mr. Gondel saying there's no other accommodation, and given that the argument was before him, we accept that, the references for that are Ms. Young's statement at 2C 180-2583, 2C tab 180-2583, skeleton argument, that's Ms. Young at paragraph 50, skeleton argument, the High Court at paragraph 53, and that's core volume 2, 1A, tab 42, 672, page 672. So the arguments there Mr. Gondel's evidence is there, and the conclusion is it's common ground. That's why, perhaps understandably, he said it was common ground, that the UK cannot in practice provide the claimants with their full convention rights within the SBAs. Cannot in practice, not in principle. You are dealing with practical and effective delivery of rights. That can't happen in the SBA, even taking into account the possibility of internal location. Okay. Then if we go to 358, it's fair. I don't want to present this unfairly. I'll tell you if I have. In 358, the judge says, against letter E, on the current evidence, there appear to be only two alternatives that would lead to a durable solution, which it is common ground needs to be found. It's effective resettlement in the ROC or in different accommodation, but in either event under the protection of the ROC or resettlement in the UK. He's contemplating those two because he has found the Refugee Convention does not apply. And this is his, we say, overly austere view of spirit. But even that is was not a lawful option because the failure to adequately consider the concerns of the UNHCR, September 2013, 4 years ago, means that the decision would be vitiated. And that conclusion about the Refugee Convention is obviously overset by the Court of Appeal, and they very clearly take remaining in the SBAs off the table. You look at paragraphs 81 and 82 of Lord Justice Irwin, and they do it, my Lord Rees absolutely right, by reference to Article 34. It's not possible for Refugee Convention obligations to be satisfied by resettlement there. And then there's a conclusion, a principal conclusion, not his only conclusions, but a principal conclusion at paragraph 397.2, page 467, physical social infrastructure of the SBAs incapable of meeting the obligations to a recognised refugee under the convention that would be expected of the body responsible for governing the SBAs. There is not a detailed finding seriatim through the convention rights. Why not? Because of this common ground position. Please can I take you to the documents that we list at paragraph 144. Sorry, before I do that, can I just say that and these examples are So these are contemporaneous documents that we list which show the possibility of the SBA being able to deliver on the UK's commitment material you've already seen. 145, this is where I say Mr. Eady 3 times in documents that he authored, 3 times says, 145, summary grounds, SBA's limited military purposes incompatible with assuming the full obligations under the 51 Convention on a permanent basis, in particular employment welfare obligations in 26 and 34. It's the first time he says it. You've got the reference there. Second time he says it, detailed grounds. SBA's limited military purposes incompatible with assuming the full obligations on a permanent basis. Doesn't provide any schools, doesn't have a formal welfare system. You've got the reference there. The third reference is same document, the next page, at paragraph 53. That's why we say it was common ground. I was slightly surprised to learn yesterday it's not common ground. He's not allowed to say that with great respect. Particularly when he didn't appeal the findings that Mr. Justice Foskett reached based upon this common ground position. And then the material that we cite here post-dates the MOU, my answer to my Lord Sumption's point. Post-dates the MOU. So, resettlement within the SPAs was raised in evidence, in argument, the courts rejected it. There's been no application to this court based on some dramatic new evidence to show a fundamental change of circumstances. It is not open to the Secretary of State we submit to say that the decision could properly be based upon the idea that the convention can be complied with in the SPAs through whatever medium. It is closed because of the stance she took, the evidence she advanced, the arguments she made in front of Mr. Justice Foskett, and the fact that she did not appeal a single one of his findings. Now, I want to now just briefly address you on the issue of housing. All I'm going to say is that even if you look at their letter, and I only need one right, Lord Panic in Miller, one right, access to the ECJ, I just need one right. If you look at housing, the letter, even if you look at the letter of July 2017, it says nothing about housing. Under current living conditions, it says they could move to the ROC, and that's at 2D, tab 228, 2907. And even the Secretary of State accepts, with some understatement, SFI, paragraph 32, page 127, that it would be, quote unquote, difficult to relocate within the SPAs. She accepts that they should leave Richmond Village, but doesn't answer my Lord Wilson's where question. In reality, this option collapses to go to the Republic, because you've not got anywhere else to stay, and agreed fact, there is asbestos in potentially harmful qualities, paragraph 26 of the SFI. May I just deal with Article 34 very briefly? If you look at our case at 176, paragraph 176, page 238, you see that the SPAA, sorry, my lord. At paragraph 176, page 238, SPAA has accepted the reference you've got at footnote 106. No true nationals of the SPA's only permanent population comprised of nationals of the Republic, remainder expatriate British nationals who reside there temporarily, etc. BOTC in the SPAs doesn't confer anything like the panoply of political and civil rights, normal incidents of nationality. Unlike the position in all other British overseas territories, BOTC citizenship in the SPAs doesn't provide a route to British citizenship, which can therefore only be acquired by naturalisation, a process that requires a 5-year residence period. Secretary of State's refusal bars that route. And then the Grell Madsden and Hathaway that I mentioned in answer to my Lord Sumption at page 239, paragraph 179, Article 34 is breached by a failure to provide any route to assimilation or naturalisation. Professor Grell Madsden, in the underlined text, if, for example, the state outright fails to allow any refugee to be assimilated or naturalised and isn't able to show any other reason than unwillingness, the contracting states may have a ground for complaint. He's talking about international states being actors, so other contracting states. Are the SPAs unwilling? No, they're unable. Is the UK unwilling as the contracting state? Yes. The UK is unwilling to see the Court of Appeal. Professor Hathaway describes this as a very sensible formulation. Despite the minimalist nature of the duties, Article 34 is breached when a state party simply does not allow refugees to secure its citizenship, refuses to provide a cogent explanation for that inaccessibility. The explanation we seem to have is pull factor, politically unacceptable, it will look bad. may draw. That's not a proper reason. Because the state shall facilitate as far as possible the assimilation and naturalization of refugees, it is incumbent upon state parties at the very least to provide a good faith justification for the formal or de facto exclusion of refugees from naturalization, formal or de facto. That's the position here. 183, just in case there is still some scaring of the horses going on, give you the example of the person in the Cayman Islands. He can be assimilated there as a refugee, no right to seek to travel and settle in the UK unless other aliens in Cayman have that right. See Article 26. It's the opposite of what he says it does, Article 26. That isn't the position here. My client's assimilation can't be facilitated to any degree. That's her case. It follows the UK must choose where in its territory it can discharge the obligation. The metropolitan territory is the obvious and here the only available option.
Can I ask you about that point? I mean, we're talking about a very unusual situation in international law where, possibly unique, where areas are carved out or retained which, by international legal understanding, are given a very restricted purpose and are reliant expressly on the neighbouring country, on the Republic of Cyprus, which is the real continuation of the island's existence in one sense, for the provision of a wide range of public services to be performed for Cypriots in the sovereign base areas, including education, agriculture, cooperative development, etc., social welfare. Now, that's been extended by MOU for understandable reasons. I just wonder whether, I mean, you read the concept of nationals in an entirely conventional sense, but when you're talking about securing the same benefits or the most favourable benefits that nationals have, I just wonder whether in this context the convention wouldn't be read with a light to the actual situation on the ground, and whether it shouldn't in international law be read as effectively treating the requirement as being that refugees be treated in the same way as those who are others who are ordinarily resident in the sovereign base areas. The military and so on seem to me a rather special case. I mean, they're here on secondment.
So the idea is to finesse the word own nationals and replace it with foreign nationals, with great respect.
It's not. I mean, the idea is to recognise the reality of the situation, which is that the sovereign bases are necessarily dependent on the Republic of Cyprus for a large number of facilities, indeed for their existence, actually.
That would make sense if there was some sort of in right-of concept that was operative in international law. It would make sense, but you don't have that, for the reasons I mentioned earlier. It's a domestic constitutional concept. There's sort of controversy over exactly how it works. Quark, Berkeley, Banku, Finis, KU, but we just don't have it here. You don't accede to a convention in right of an overseas territory so that the only relevant territory is that overseas territory. That would be to turn Article 29, customary international rule codified in Article 29, on its head. And if you're going to construe, if you're going to depart from the literal meaning of the Refugee Convention, you go one way. There must be at least 10, 15 House of Lords Supreme Court cases which say that. Iran, RT, Zimbabwe, ST, everybody says, Lord Bingham, Lord Hope, everybody says you construe the Refugee Convention in the light of its object and purpose, which is, I'm sorry to repeat it, to assure refugees the widest possible exercise of their fundamental freedoms. Why? Because these are people who have been denied that by the actor in the international plane who is supposed to give it to them, their national state. Here, let us not forget Iraq, Syria, Sudan, Eritrea. So just to continue at 240, in the middle of paragraph 183, Secretary of State is therefore wrong to assert, we respectfully submit, that Article 34 must, in the present context, refer to assimilation and naturalisation in the SPAs, we submit it's the opposite. It's the present context which means that the UK must choose where, other than the SPAs, in its territory, that right is to be discharged. That's all I wanted to say about Article 34. Then can I move to the proposition that relocating to Cyprus, the Republic, is contrary to the Convention? You have our submissions at 153, page 232, 153 onwards. This is a bifurcated submission. Each submission is sufficient to make my point. The easy way of putting it is to say you can't predicate your solution on something that the Refugee Convention doesn't allow, which is non-consensual transfer. If you look at 157, you'll see that Hathaway says that the window of opportunity for mandatory resettlement is quite short. It ends once lawful presence is established, at which point the strict limitations on expulsion set by Article 32 apply, so as to make enforced resettlement unviable in most cases. Reference is at the footnote, you'll see at the bottom of the page, and the reference to most cases is because saving national security, public order, right, where you don't have the right. It's volume 7, tab 80, page 9250. The reference to the handbook, Mr. Fordham deals with that at his case, paragraph 9, footnote 8, page 307, and the references are volume 10, tab 120, pages 6305 to 6318. You will see that the UN handbook is absolutely shot through with references to consent, informed consent, freely given consent, genuine consent, and consent is defined at 6318. What that document does is just extract the relevant pages where consent appears. So at the end of that document, at page 6318, consent is defined as not given if agreement is obtained through abuse of power, force, or other forms of coercion. It is no answer to say that, hey, there's no actual expulsion, constructive expulsion, therefore it's just an option, it's perfectly fine. Mr. Fordham gives you the three-walled prison in Belmarsh. I'll give you the case of Chikwamba, or any case. You've got a Zimbabwean refugee. He can't go back to his home country. You've got a failed asylum seeker from Zimbabwe who is his wife. They have a child. She is asked to go back and get entry clearance to come here to live together. The issue is, can you justify the rupture under Article 8? Can you justify their separation? No one says, well, it would be an option for the refugee to go back to Zimbabwe. We're not expelling him, contrary to Article 33. He's just got that option, he can go. There's no rupture. The point is, you cannot predicate your decision on an illegality. In that case, Chikwamba, it's Article 33 of the Refugee Convention. In Mr. Fordham's three-walled prison in Belmarsh, it's Article 3 of the ECHR. Here, it's Article 32 of the Refugee Convention. If we need to show constructive expulsion, we respectfully submit we can. It's more difficult, I entirely accept that. The first way of putting it is, with respect, absolutely self-evident. But if we need to go to constructive expulsion, we can get there because of this carrot and stick policy that we have referred to at 161 and the materials that we've referred to at 159 through to 167. Mr. Eady says this was a finding of fact. We say the judge erred in focusing simply on the arrangement with Cyprus, and that if we were required to go pursuant to the arrangement, it wouldn't be a constructive expulsion. What was mandatorily relevant, controlling, was this ministerial long-standing policy of pressurizing them to stick to get them to move. Paragraph 166. Those are my points on the option of going to Cyprus. And I've made my points on remaining in the SBAs. I've made the point that actually on analysis, the Secretary of State's position collapses to the point that I've just been dealing with, because she's not identified any other housing. We've made the point that certain obligations can't be exported to another state. Article 34, classic example. Responsibility cannot be transferred. And then, and Court of Appeal, paragraph 80, page 358. And then MOU. So you have our submissions on that set out at 189 onwards. But I want to focus, if I may, on the design flaw. Yeah, and Mr. Hickman rightly reminds me that this is an alternative case. If you are with me on the Article 3 submission, and you are with me on my submissions about the SBA propriety being settled, then that's it. This is an additional reason why, if you're against me on either of those submissions, why we say it doesn't work. Can I please take you to the MOU? It's core volume 3 at 1B, tab 35. And it's page 1085. So it declares that the UK has the responsibility. That's not in fact what it was seeking, but leave aside that. It was seeking a wholesale transfer of responsibility. We actually submit that what this affects is an unlawful, at least pro tem, transfer of responsibility. And then, third paragraph, importance of international obligations. Fourth paragraph, bearing in mind humanitarian considerations such as those reflected in the 51 Convention, the need for the Republic and the UK to work together with a view to devising practical ways and means. Even here, in the context of a local memorandum of understanding, even here, it is the UK. The SBAA absolutely was competent to enter into an MOU, not an international agreement as defined. But even here, it's the UK, to work together with a view to devising practical ways and means of respecting rights and satisfying the needs of asylum seekers and legal migrants. So that this is obviously prospective. We're refugees, but it was extended, it seems, in 2005. You've got that in our case. 2008, they reneged the Republic. And then the next paragraph, a remaining commitment to non-settlement. So insofar, my Lord Reid said it could be said against me in respect of Article 34, assimilation. There's no answer on naturalisation, none. But if it could be said that assimilation, this is the answer. Well, look, we say, how so? This is asserting non-settlement. So insofar as it's allowing us, it's just us. And then considering the need to avoid creation of incentives and so forth, and then if I can go to paragraph 10, this is the as-if provisions. Subject to paragraph 13, during their stay on the island Cyprus, person recognised as refugees or granted any other form of international protection under the procedures determined in this memorandum will be treated so far as the authorities of the Republic concerned as if such persons had been recognised as refugees granted another form of international protection by the Republic of Cyprus. Now that is very problematic because it means the standard of treatment to be afforded to the respondents is determined A, according to Republic standards, and B, determined by Republic authorities. And that is an absolutely, with respect, obvious breach of the obligation. You don't just transfer your responsibility because a refugee is inconvenient to you. Mr. Eady responds to say, well, it's perfectly fine. The Republic is a contracting state. It honours its obligations. The problem is it's the wrong contracting state. The right contracting state is the UK. So that's what we say about about paragraph 10. And then the point about paragraph 11, the undertaking to repatriate as soon as possible. We say that this suggests a temporariness about the whole thing. But paragraph 12 is key because here, this is very interesting because it makes the instrument totally unfit for what's sought to be achieved. You'll recall the options on the table are you relocate within the SBA, which actually isn't available on the judge's findings. It collapses anyway to moving to the Republic, or you resettle in Cyprus. And here you have, or the Republic I should say, here you have the Republic and the UK promising to each other that they will endeavour to settle persons recognised as refugees in countries willing to accept them not later than a year afterwards. Mr. Eady says, well, the temporal problem can be overcome. It's not a problem at all. This is being applied. The fact that 18 years have gone by after 1 year, it's not a problem. But he doesn't answer the other point that we consistently make. And that point is that it is implicit in this that the ROC and the SBAA are excluded as potential places of resettlement. It makes absolutely no sense for the UK to owe an obligation to the ROC to endeavour to settle the respondents in the ROC. Make any sense at all? It also excludes the respondents remaining in the SBAs. The SBAs are not another country willing to accept these persons in which the UK will endeavour to settle them. So this demonstrates that the MOU was never intended to provide a durable long-term solution, still less in the SBAs or the ROC. Long-term residence was something that the parties were long-term residence in the ROC or the SBAs was something that the parties promised to endeavour to avoid.
I don't understand how an aspiration to find countries willing to accept them somehow torpedoes the rest of this memorandum.
Well, it's not an aspiration, it's an endeavour.
Very well.
And I'm sorry if I'm taking a fine point. The point is, you are resettling them in one of two states on the basis of an instrument in which you're promising each other that the UK will endeavour to do it. UK's, what's one way promise? It is promising it will endeavour to do it somewhere else. 12 makes sense with the preamble at the penultimate paragraph at the opening of the document at 18085, which is non-settlement. UK is committed to non-settlement. Well, how does that... So 12, UK will endeavour to resettle these people in... It must be other countries. It can't be the Republic. It can't be the UK. Or the SBAs, rather. So
Yes.
It just doesn't make sense. If Mr. Eady can rely upon the MOU, and the Republic only enters the arena through the medium of this instrument, which, as you said, has never been reduced to writing in respect of refugees. Who knows what the reasons are? They've not been disclosed. We've said that it's reasonable to suppose that attempts would have been made to obtain something like this in writing. But even if you got something, this just doesn't make sense. Perhaps it's because they need something else. Who knows? It's sufficient for me to say there is a design flaw here. And then in terms of security, at paragraph 18, we see that it's terminable unilaterally on 3 months' notice, and that disputes about interpretation should be resolved by consultations. Mr. Eady says, well, it's fine, you've got the benefit of it. We say it's not at all clear that if you get recognition, given that the orders actually say that you're recognised pursuant to this MOU, not at all clear if you terminate the MOU that you haven't terminated what follows from that initial act. It's not clear. Those are my submissions on the MOU. Last gasp on this, if you're against me on everything under this head, only then do I need to go to the UNHCR. And therefore, we say that remittal, it only arises if you rule against me on relocation being okay in the Republic, you rule against me on the viability or whether it's being even open to Mr. Eady to say, well, they can stay in the SBAs. You rule against me on the idea that it's possible to export refugee rights and transfer responsibility, and you rule against me on the MOU being fit for purpose. It's only then that we get into, well, we need time, Mr. Eady says, to respond to the UNHCR document, which was sent to his client on the 26th of October. He says in his case that we didn't rely on it until the 24th of November. That's absolutely right. It took us a month to rely on it. Perfectly accurate statement of fact. Missing a slightly important detail, they disclosed it to us on the 24th of November after repeated requests.
There may be difficulties about your relying on that very recent document. Presumably, however, you can rely on the UNHCR 2013 document.
Absolutely, I can. Absolutely, I can, my lord. And we say that even if you get to that place, you should resolve the issue in our favour and make the order that we seek for two reasons. Everybody who's looked at this case recognises its urgency. There is, and Justice Foskett actually said it was because of the asbestos. He said that at paragraph 74, page 385. The Court of Appeal refused to stay on its order. You may recall the Secretary of State moved this court and then made the decision. The court granted expedition on the Secretary of State's application. So everybody understands there's a need for this saga to end. And then secondly, the views that are expressed are not of an overzealous NGO, but the UN High Commissioner with public law, what in public law terms would be called institutional expertise and constitutional responsibility. That's paragraph 196 of our case. the state parties agreed to confer on the United Nations High Commissioner the right to supervise the application of the Convention under Article 35. That's what it says. Article 35 of the Refugee Convention says exactly that. And they are supposed to cooperate with his office. Duty of supervision and cooperation. And we say it is with respect not on for the Secretary of State in cases such as EM Eritrea, which some of my lords will recall, to make great play of the lack of UNHCR unequivocally condemning a state, Italy in that case. Mr. Fordham for the UNHCR was greatly pressed on that issue. But then to say, well, I can sidestep his views in another case because they're inconvenient to me in circumstances where this view has been held for 4 years.
Mr. Hussain, can I just see how far you take this? Miss Lisa Young has made 2 witness statements.
Yes.
In which she has, in some detail, explained that at successive meetings with the authorities in the Republic of Cyprus, they have made it perfectly clear that they are willing to observe the MOU in relation to these particular refugees. Now, that's her evidence. Are you saying that because the UNHCR has written in the terms he has, we must disbelieve that?
Not necessarily disbelieve it, but you can't rely on it. You can't rely on it because of the history, first of all.
I can't rely on it because, I mean, are we allowed to form a view on whether it's true? And is it implicit in your submission that because the UNHCR has expressed a different view, we must reject the evidence that's been given directly in this case?
As unreliable, yes, I don't need to go any further. And the reason for that is that the reliance placed on the UNHCR has been reliance on a local officer. The letters that you've had are from Mr. Volker Turk, who is the Assistant Director of the Assistant High Commissioner.
Now, I'm talking about Lisa Young's own exchanges with the Republic of Cyprus.
That if you want to go into new evidence territory, no application to abuse new evidence.
No, I'm talking about
also
the existing witness statements that she has made for the purpose of these proceedings.
Yes. Well,
I mean, was there any application to cross-examine her?
no, but we had said that it is given that there was at the very least a very uncertain compliance with the MOU, that it wasn't reliable. One second.
I ought to remind you, Mr. Hussain, that your time is
I'm about
up.
to sit down. I was about to sit down.
You're about to sit down and then somebody gave you a note. Yes. Well, you have time to look at 2 notes.
Well, I'm being sorry. Mr. Shirley deals with the existence of the MOU, not the rights. I better sit down and let Mr. Fordham have his turn.
Well, thank you very much indeed, Mr. Hussain. Mr. Hickman?
1649.
I have the other one. My lady and my lords, our printed case is 13 pages, and it's at page 303 of Core Volume 1. A description of who we are is at pages 49 to 50 in Core Volume 1. We accept, in response to Lord Sumption, that in principle the refugee rights could be provided by the United Kingdom in an overseas territory. The judge in the High Court, paragraph 303, recognised at the end of paragraph 303, page 444 in Core Volume 2, that provided, he said, that the obligations under the Convention can be fulfilled within the non-metropolitan territory where the refugee is lawfully, he didn't see how there would be a right by reference to Article 26 to leave to enter the metropolitan UK. That's correct. He also, though, recognised later at 346 that leave to enter the metropolitan United Kingdom might be the only solution. Letter D on page 456. That is also right, and it is. They've had 19 years, and yes, they could have been building and taking the steps that would be necessary to secure the relevant rights. They could also, in principle, have opened the gates. I say open the gates because there are 7,500 British families, family members, that are located in these areas. The judge dealt with it at paragraph 57 on page 380. And the witness evidence is in 2C at tab 176 that he's referring to. You saw it this morning, so I don't go back to it. But you've got there life beyond the wire. Health, education, recreation, library, gym, sports pitches, 4 primary schools, 2 secondary schools, fully equipped medical centres, a community psychiatric nurse, clinics, a cinema, a pub, banks, a church, shops, a travel agent, hairdressers and a golf course.
Is this in Akrotiri?
I think that's a description of both of the
Or
bases.
both of them.
You'll see it's at page 380, but it's in Ms Gregory's witness statement, 2C 176, tab 176. We say it is wrong in principle to say, as the state of refuge under the Refugee Convention, you can sleep on our territory, assuming somewhere habitable, and you go each day across the border for your education and your association and your social security and your work, your basic economic and social rights, the basic economic and social rights that we have described in our printed case at paragraphs 5 to 8. Why is that wrong in principle? Because the United Kingdom is the state of refuge. The United Kingdom owes the obligations and the United Kingdom has to deliver them. There can be a transfer of responsibility, that's the phrase, in certain circumstances. You'll see this at page 307 in our printed case, about 6 or 7 lines down where we're citing the Michigan guidelines. A transfer of...
What was the reference again?
This is page 307 in our paragraph 9.
Yeah.
We're citing page 6363, volume 10, tab 123. A transfer of protection responsibility which respects the requirements of international law may be made only before the refugee concerned is lawfully present in the sending state.
I mean, the reality is it comes back to it that your submission is not ready to make any allowance for the reality of the international arrangements which have been made and the peculiarities. It isn't possible, effectively, for the UK to deal with it in the normal way.
I don't accept that there's no allowance. What I submit is there's a line. And the line is to be drawn where you identify the state of refuge and its obligations. And if you just think about that line
and change the factual scenario. If you can say, go over the border for your school and your clinic and your social security and your work, why stop there? Why not say, sleep there? And as soon as you see that, the line is then clear. You say, well, look, we've got to operate in the real world. We're supposed to cooperate. We want to deal with your rights. Here's what we're going to do. We've done an arrangement, and you should go over there and do all of that. And we know we can't have that because that's immediately the constructive expulsion, because that line is drawn very clearly. Once you are lawfully...
Maybe it would be in this context. I mean, the truth is the sovereign base areas are in certain respects sort of satellites, aren't they, of the Republic of Cyprus, where they aren't fully formed territories in reality. They don't operate, they don't have the capability to operate. But, I mean, the submission is, maybe it's the absolutely right submission, but the Refugee Convention will completely ignore that and ignore any international arrangements that might be made.
The Refugee
Can I
Convention...
just add to that? And does the UNHCR take such a strict line? Because they seem to be accepting that if there were satisfactory arrangements with the ROC, that would...
I can't speak for the UNHCR. I'm not here for the UNHCR.
No, but
the UNHCR's position is that you cannot move someone to another state to meet their right
No, I understand as a general...
without their consent.
I understand as a general proposition, but in this particular case where we've got interventions, the UNHCR, who are trying to find a solution, they don't seem to be taking the very strict line you're taking, do they? Or have I missed something?
They certainly didn't originally, did they? They may have tightened up more recently, I think, but as I understand it, my Lord's right, that originally they were working on making the thing work.
I mean, as I understand it, they're saying, you know, we've tried that, the arrangements aren't working, therefore the only solution is actually to bring them to this country.
That's certainly right. And one of the things that was being explored was an arrangement that would be consensual because it would sort the problem. And everyone's entitled to do that, but there is a line to be drawn, and it is a line of principle. It's not unreal. It's not unrealistic. In the real world, you arrive where the penguins are, and it's recognised that you are a refugee. And the British take responsibility for that, as they did in this case, and you are lawfully present. What in the real world happens? The state of refuge takes you to a place where your rights will be accorded to you by the state of refuge. And so we say it's very revealing that you couldn't say, and by the way, go and live there as well. And you only have to look at the housing provision in the Refugee Convention, because it talks about where you stay, you have to have housing. And if it's right that that the UK can't come before you, and it doesn't, Secretary of State's not here saying, well, we can do an arrangement where in substance it's all going to be delivered by another state. And for that matter, the answer to the asbestos is that they could go and live in the Republic of Cyprus. That's a revealing position. And you could turn it round and have everything else provided for in the SPAs, but you've got to go and live. The housing is Article 21 in the Republic of Cyprus. We don't accept that that's unreal. It is a principled position, and it's the correct position. And the United Kingdom could have said, these are asylum seekers, and we're going to make an arrangement, like the Dublin type arrangement, to get them somewhere else, a safe third country. What you cannot do is recognise a refugee for whom you are responsible, give them the document that says you are lawfully present here, and then say, well, you have to go to another state for the provision of your rights. And all of this is at a level of principle before you get to the fact that look at the reality after 19 years. Now it's the United Kingdom's responsibility. The purpose of these refugee rights in the Convention is that you can function integrated in the society of the country of refuge. The judge at paragraph 345 described these as the essential rights. And he recognised that these essential minimum requirements, that's his exact phrase, essential minimum requirements, paragraph 345, are the responsibility of the United Kingdom. And so they are. And if you look in our printed case, and I don't take time with it, but commend it to you if I may, you'll see the description of what the purpose is of these rights. Paragraph 6 on page 305, these are basic economic and social rights, including gainful employment, essential to achieving self-sufficiency and family security for refugees. That's EXCOM. So that's the 100 states who are the governing body of UNHCR, 101. And over the bottom of the page and over the page, the goal of the Refugee Convention, refugees will lead an independent life in the countries which have given them shelter, integrated in the economic system of the countries of asylum. That's the purpose, so that you can live as a human being integrated in the country of refuge. And if it were an answer to say, oh, well, let's get real, in the real world, they should go and do this in the Republic of Cyprus, well, let's call a spade, make them, say they have to do it. We're not going to provide anything because it's there for them. And the Secretary of State cannot adopt that position before you because it's incompatible with the Refugee Convention.
Well,
and adding in...
Well, you say that, and you refer to a UNHCR document which uses the word consent. We're concerned with the treaty, not with the UNHCR document in the first place. And the document, no doubt, will be true in virtually all circumstances. But it's again a question whether some recognition can be given to the fact that this is a very unusual situation where you have a British overseas territory which is completely interdependent, it's really dependent on the Republic of Cyprus. And can the refugee who has arrived at the SBA simply dig in his heels and say, well, take me to London?
Once you have a recognised refugee who is lawfully present on your territory, the time for the transfer of protection responsibility is over. That's not just the UNHCR. That's every authoritative commentary on the impact of Article 32. And so it's right to test it and say, let's suppose there'd been discussions and they're in a witness statement, and it's now a position that if you just go across the border, they say they'll provide for your rights. You cannot do that, and you cannot do that because of the express terms of the Convention. Because that would be safe third country, there's somewhere else you can go, they won't refool you, they'll meet your refugee rights, but we are forcing you, when you're lawfully in our territory, and when we've recognised you as a refugee, to go to another country.
But you say that's an expulsion, do you?
That would be an expulsion, yes.
It's an expulsion to say we will provide you with all these services because of the kind of territory that it is. The convenient way to do this is to provide it through the Republic of Cyprus, 20 miles away. And well, you say that's an expulsion.
It would be an expulsion to say, my answer to that is yes, it would be an expulsion to say they will provide you with all of this, including your housing. You should go across the border.
Under the MOU, the immediate provider is the Republic, but the UK reimburses them for the cost of doing that, under Article 13, from memory. So, I mean, the economic reality is the UK that's doing it, but it's doing it in a more convenient way than trying to create a civil society on a military base.
Well, I come back to my submission, call a spade a spade. Why isn't Mr. Eady saying to you, We've got an arrangement where everything can be provided that a refugee will be entitled to, but they have to be over the border in the Republic of Cyprus. He isn't saying that because he needs to have an answer to expulsion, and his answer to expulsion is they can still sleep in our territory.
Well, normally an expulsion is a definitive requirement to go somewhere else. Now, the fact that that you say we will provide you with certain services over the border, you can come back whenever you like. We're not telling you you must stay away. We're simply providing you with the services over the border. Is that any more significant than, let us suppose, that there were no supermarkets in the SPA, and in practice, to go shopping, they had to go to Larnaca or wherever? Would that be an expulsion?
Would it be an expulsion if you said, well, you can still come back if you want to?
If you simply said, I'm sorry, there are no shops where you can buy the necessaries in the SPA, but there are on the other side of the border, and so...
no, that's not an expulsion, because there's no refugee right to...
Well, what's the difference, simply by virtue of the fact that the service in question is a governmental service that the SBA is providing through the Republic of Cyprus?
The difference is that these are the refugee rights that you have under the Convention that the United Kingdom has to provide in the country of refuge. That's the purpose. I need to move on, if you'll let me, and I'm going to cut some things anyway, but I'll try and assist where you want assistance. It doesn't help to add in the Cypriots that are present. For a number of reasons, you've seen rights that are referable to comparisons with nationals, primary education, Article 22, social security, Article 23. You've seen the longer-term rights, naturalisation, Article 34. But even the right to work after 3 years, restrictions are to be removed, Article 17.2. And again, the purpose is to be able to function as a human being in the society of the state of refuge. So it's no answer to say, go and be gay over the border. Go and practice your religion. See Article 4. Over the border. But even if it were, we respectfully submit there has been ample time for a solution to be found and put before you, if there is one. This case has been recognised as urgent by everyone, including both of the courts below, and the Court of Appeal confirmed it at 84 to 85. And you simply have, in our submission, nothing sufficiently concrete before you that could constitute the United Kingdom saying, well, we have delivered through another means. The Court of Appeal rightly recognises that you can't export paragraph 80. The United Kingdom cannot export the delivery of its Refugee Convention obligations. Mr. Hussain is right to draw attention to Article 19, which is the one that permissively provides that you can move people, you can move refugees around from your municipal to your territory for whose international relations you're responsible. Page 3146 if you want it big, 902 if you're looking at it small. And yes, you can deliver through relocation. In this case, you need to deliver through relocation because you cannot provide...
Well, wait a minute, that's only liberal professions, isn't it, Article 19?
Yes, but what it illustrates is that you can deal with refugees by moving them around.
Well, this is a benefit for them. This is a perk, which, in a rather elitist spirit, the Convention seems to have given to the liberal professions.
Right. But my point is simply this, that the Convention is recognising that there may be movement under your national provisions from one of your territories to another of your territories of a refugee. And the logic of this case is that the only way these rights can be secured is by a movement of that kind. And yes, it's not the liberal example that's in Article 19.
One can envisage the opposite situation. Let's suppose somebody seeks refuge in buy it in a rather, well, maybe Cyprus is a very pleasant part of the world, but they wanted to stay there, and the last thing they wanted to have is to come to the rainy metropolis of Great Britain. And yet, in the local area, the convention rights weren't being observed. Surely wouldn't they come to this court and try and get an order from this court that we secured the rights in that situation?
And this court would say, no, your right as a refugee is to have your convention rights delivered to you by the state of refuge. That's the answer.
Not in the place where you arrive?
No.
I see.
Can I just show you Article 25, page top of 906 or 3150, depending which one you're looking at. There is a provision that talks about administrative assistance from the authorities of another foreign country, but it's very narrow and it's very specific. It's where, as a gateway to your right that the state of refuge has to provide, you normally would need the assistance of an authority of a foreign country to whom you can't have recourse. And the obvious example, and you see it from 25.2, is where you need a document. So we say, we've got our welfare provisions, but you need a birth certificate or you need some sort of document in order to access them. But it's quite interesting that that's a very specific provision to deal with the situation where you need normally assistance from the authorities of a foreign country. Even then, if that's not available, the duty is on the state of refuge. End of 25.1. But there's no provision in all the world of refugee cooperation and different states cooperating. There is no provision that says you can discharge your duties through another state. And that would do through the back door what you can't do through the front door, because the safe third country is for asylum seekers and expulsion is for those who are a national security or public order risk. And that's the structure of the Refugee Convention. Can I just see what I can rattle through in 5 minutes? In our submission, the Court of Appeal didn't disturb the findings that had been made in the High Court about the inability to deliver these refugee rights. They also made clear that it was very likely that without leave to enter, there'd be a failure to meet the UK's obligations. The UK's obligations, they'd said you can't export them, and they made clear at 85 what was needed was rapid resettlement. That was either going to be, there is now a concrete solution that everyone's happy with, which you can always do, or it's going to be resettlement to a place where the rights will be delivered. Article 40, I'm going to touch very lightly. I don't have any choice. Just 2 points, if I may. Mr. Eadie emphasised October 1956. What's happening? He says the UK is consulting. That reflects the significance of social and practical conditions, local constitutional organs, local laws, local interests. And yes, it does. But Article 40, paragraph 3, specifically deals with that. It arises at the outset when you're making your declaration, because you can consult with and get the consent of the governments of such territories. And it's worth noting, 3157 or 913, that Article 43 does not say the consent of the territories. And if it were entity, why wouldn't it say that? Why is it a reference to the consent of the governments of the territories? Well, he accepted. This all arises out of Vienna Article 29, where territory is land. The second point in relation to Article 40 is Mr. Eadie emphasises May 1963, when there is a new notification from the new independent Republic of Cyprus. And he says there's a new independent state making its own decisions about treaties and choosing for itself. True, but what's happened is that Article 40 can no longer bite because 40 is applicable to a territory for whose international relations you're responsible. You're not responsible for the international relations. If you're looking for a yardstick for discontinuance, you don't need to look any further. That's where you have discontinuance. To the extent that you're no longer responsible for international relations, it has gone. And given that Lord Hoffman was finding a yardstick, he said from the wording, we say that's the yardstick from the wording. And just 2 footnotes to that. We're supported in that again by Article 19, liberal professions, because Article 19 in terms uses the same language, but is talking about people settling in the territory for whose international relations. You don't settle in a political entity. And even the notification itself that Mr. Eadie was relying on, it's page 1242, volume 2A, tab 54, that notification itself uses the word territory in the way that he is arguing against. You'll see when it talks about this was the territory, we're now independent, and there was previously a notification in relation to the territory that we now have. Finally, I do need to just deal, I haven't got time to do more than give you the headlines, with the policy position. There's a policy here which involves a commitment to act in the spirit of the Refugee Convention. The documents say, and one of them calls it a policy, it's a written answer, the documents say that means apply the principles of the Refugee Convention. The documents say accept responsibility, I'll give you these references in a minute, for the recognised refugees. And the documents say delivering the Refugee Convention rights. And the pages are 1458, 1447, 1334 and 1357, where you'll find all of that. So there's no difficulty with spirit.
Sorry, could you just give those again, please?
1458, 1447, 1334 and 1357. Spirit means substance. Public law requires, because it's a policy, that you will deliver this right, that you deliver it. It's not legitimate expectation. We've made the point in our printed case, and we have cited the Evans case. The Evans case was missing. You only had the head note, so I'm sorry if you were searching for it. We've now got a bundle that's got the Evans judgment in it. And because I've run out of time, I've got a minute, I think, I'll give you the paragraphs. It's paragraph 1 and 237 to 239. And Evans is a case where there was debate to be had about where Article 3 of the ECHR applied in Afghanistan to the transfer of detainees. But they had a policy, and the policy was that they would not transfer if there was a real risk of torture or serious mistreatment. And the court says we apply that standard, and it reaches conclusions at 315, 320 and 322, deciding that some transfers couldn't happen because they were incompatible with the policy, and some could only happen if certain conditions were met. The court says well-established legal principles at 237, and they didn't need to resolve the issue of law of whether Maya Evans could rely on Article 3. She wasn't a victim, she was a peace campaigner, and they didn't need to resolve issues about whether the Secretary of State was acting as the UN or for the UN.
Where do we find the reference?
Evans, the full judgment is in this black file that we've all put together, but I don't know whether anyone's actually handed it up yet. And it's, I think, tab 1.
I don't think so.
So
We can remind ourselves about Evans at a later date.
it's in here, and if you remember
Virtually all of
Lombard,
us.
you'll remember it was only the dissenting Lord Phillips that thought this was legitimate expectation. The public law principle is that you have to adhere to a clear policy. So for public law reasons, the Secretary of State would be held to what she committed herself to which was applying the principles of the Refugee Convention to these individuals, leaving aside the interesting questions about territorial extension. That's all I've got time for. Thank you very much for having us here to react to the questions that you asked during the hearing. Those are our submissions.
Thank you, Mr. Ford. Thank you. That's probably a bit fast. Anyway, you can have your full half hour, Mr. Eading, should you require it.
Should I require it? Issue 1, if we can go back to issue 1 briefly. The key question under issue 1, as I think we all now agree, is whether the declaration and notification made in 1956 continues without more to bind in relation to the SBAs, or whether it lapsed as a result of the changes in 1960. And we make 4 absolutely basic and core submissions in relation to that, and they are responsive to my learned friend Mr. Hussein's case. First, that declaration or notification was given in relation to a particular entity, Cyprus. Cyprus can only mean, and did mean in 1960, the colony of Cyprus, and no one appears to dispute that. Secondly, the notification was given under Article 40, and that is significant because the very purpose of such clauses is to deal with and alter the usual rule under Article 29 of the Vienna Convention on the law of the treaties. His case, my learned friend Mr. Hussein's case, invites doing directly the opposite and reverting, in effect, to the application of territory equals land and or sovereignty. Territorial application clauses are specifically designed to allow for the separate provision that is made for such territories. And we know from the Travo that Article 40 itself was so designed. And there are, as we submitted in opening, a variety of reasons for that, including, to select the 2 core ones referred to in the Travo, taking proper account of the interests of the local population, and the linked point of taking account of local conditions, including the suitability of those local conditions for the application of the rights and obligations under the convention in question, brackets, either at all or with reservations. And we do respectfully agree under this second point on the significance of Article 40 with the point made by my Lord Reid about Article 43. The example was posited, what would happen if you ended up in a situation where you had a territory get split into 2, they both become new colonies, they're both pretty sizable, they're both doing different things, and they both have a new system of government, or each has a new system of government. What then? Is it really to be said that your further consideration under Article 40 sub 3 can't work in that situation, wouldn't require you to seek the consent of those newly created entities? Of course it would. That's the very purpose of it. And my learned friend's only answer to that was to say, no, you can't use 40 sub 3 for that. What you'd have to do is to use the nuclear weapon of full-blown denunciation under Article 44. And we respectfully submit that makes no sense. That's the second point. The third point is that the 1956 notification was given precisely after such consideration, as it says in terms, after consultations have occurred with the relevant territories, including the colony of Cyprus. And on whatever basis, the judgment was therefore made in 1956 that it was appropriate, with the reservation specified, for notice to be given on behalf of the colony of Cyprus, with all the infrastructure and all the social conditions and all the constitution and all the forms of government that that colony had at that time, assessed in the light of the purposes and objects of the Refugee Convention, no doubt. Fourthly, the colony of Cyprus ceased to exist in 1960. The notification that had been given in 1956 would have looked very, very different indeed on the 17th of August 1960. And that is because the colony of Cyprus, that is the entity with all the structures and all the rest of it, that had been fundamentally affected And we don't terribly mind whether you come at this through the prism of legal entity or you come at it through a broader prism. The legal entity of the colony of Cyprus, that is the beast referred to in the 1956 notification, had ceased to exist. It had been replaced, and let's not lose sight of this, we've all been focusing on the SBAs for understandable reasons, for continuation of sovereignty and all the rest of it, but let's not forget that 90%, over 90% of the old colony of Cyprus, if one judges it purely in land terms, had now become the full-blown independent new sovereign state of the Republic of Cyprus. So if one judges it on the basis of the legal entity, the creation of that full-blown new sovereign state and the SBAs fundamentally altered the legal entities. If one judges it in the sense of territory, fundamental change, 95% or whatever the percentages are, new Republic of Cyprus, 5% the SBAs, with military bases on them. Social conditions, system of government, infrastructure, international control over the way in which the SBAs should now operate, and international agreement in relation to the manner in which they were thenceforth to operate, having regard to the fact that Cyprus was the near neighbour, and there were real sensitivities about settlement, about references to colonies, the SBAs were military bases and so on, fundamental differences. And it is, we submit, of no assistance for my learned friend to point to and rely upon, as he does in his submissions, Article 44, the right to denounce. It is no assistance to point to that in answering the fundamental question that I posed at the outset, because, firstly, there would have been no need to use it, that's Article 44, if the position is that the 1956 notification had lapsed. So reliance on the existence of that Article 44 mechanism is question-begging. But as fundamentally and purely practically, that mechanism had never been used. It's never been used, even in a case where it is entirely clear that the notification has lapsed, when dealing with a former colony which in its entirety, and without the complications of 2 bits of territory, 2 bits of land being governed differently thereafter, where you simply got a former colony that just becomes independent. Article 44 has never been used in that context. Why not? Because the notification given on behalf of the colony under Article 40 had lapsed. So you don't need the positive act that is referred to in Article 44. The inference, therefore, to put it another way, from its non-use is thus not acceptance that the obligations under the Convention continue to bind. You don't need a positive act on behalf of the UK. You don't need some indication, I think, as Lord Carnwath put it to me in opening, that they're no longer applying to the SBAs. The question is whether the original notification can properly be said to survive the fundamental changes that are made, even if some part of the land remains under sovereign control. And we respectfully submit, I'm not going to go back over them, but for all the reasons that I gave in opening, it is not appropriate to say, it is not the correct analysis to say, as Professor Finnis, great and good as he was in the last case, not so great and good in this, as Professor Finnis has said, that sufficient remained, even Homer can occasionally nod. Tiny part of land, it's not a territorial concept for all the reasons I gave, sovereignty not enough for all the reasons that I gave. So that's what we say about the basic position. What about the attack on Bonku? I referred in opening, and I just give you the reference because the authority I think is not in the bundle, sadly, but my learned friend referred to Horton and Sadler and Lord Bingham on the 1966 practice direction. That, as my lady will well recall, was referred to in the more recent case from this court of Nower, beginning with a K, 2016 AC 908. The relevant paragraphs are 22 and 23 in the judgment, the joint judgment of my lady and Lord Newburger.
But you can guess which of us wrote which part of that judgment.
Well, my lady, I wouldn't deign to presume.
Good lawyer's quiz, sir.
Yes, but anyway, there it is, for good or ill. And of course I accept that the principle is not allows for both options, if I can put it that way, but circumspection, we respectfully submit, is at the very least the principle. And so it is a challenge to a decision, this attack on Bonku, which is binding at this level. So the circumspection principle is in play. My submission is that the approach of the Lords in Bonku was the correct approach. It's necessary to have some yardstick against which to judge whether notifications or declarations do indeed continue to apply. And it's entirely appropriate, we submit, to focus on whether that notification, given under Article 40 or equivalent, CECHR, has survived or has lapsed. And the reason it's appropriate to have that sort of test is because that test recognises two things. Firstly, that notifications are given in respect of political entities, at the very least in relation to conventions such as the ECHR and the Refugee Convention. Of course, one can, in theory, no doubt, be responsible for the international regulation of land simpliciter, but in our context, we are dealing with a clause such as Article 40, talking of responsibility for the international relations of the satellite state, and one is talking, therefore, obviously about political entities. Our notification in relation to the Refugee Convention was plainly of that type, with all the underpinning and all the political and constitutional points and social conditions that went with it. So Bonku and the logic of that part of Bonku is not undermined by pointing to the mere existence of, or the possibility of, some territories with no or few people. The mere fact that that can happen does not diminish the force that you can be responsible for the international relations of such territory, does not diminish the force of that underpinning and that set of points that we've made. So that's the first thing that the test recognises, but it also recognises, secondly, the need for a principle to govern the proper inference to be drawn from the fact of no proactive notice of the kind that's contemplated by Article 44, when you have had historically changes of the fundamental type that we are dealing with here. And the bull question, it might be thought, is can you actually assume that the previous position simply carries on? There isn't any proper basis for simply applying rules based on land or on sovereignty. And what's the alternative that my learned friend offers in that situation where historically there's been no Article 44 notification or withdrawal denunciation, and yet there has been a monster change, a proper fundamental change? What is the alternative? His only answer to that is to say you need the consent of all the parties, which no one has ever sought under any circumstances in relation to our colonies that have become independent, or the operation of a denunciation provision, which I've addressed you on already. And if that isn't given, which is the premise for considering the Bonku test, the logic of his case is that the UK remains internationally responsible, in the absence of the consent of all the parties, for those in respect of whom it's previously given notification, including, we ask, the fully independent former colonies. The only other suggestion is, which was floated briefly and gently, relates to the international legal principles of succession, treaties being succeeded to. But that is, we respectfully submit, a deeply uncertain body of rules. As I think it was put by my Lord Mance in the KU case, Authorities 4, tab 39, page 4121, para 194, state succession, as he put it, is an area of international law which is neither easy nor well covered by authority. And if one goes to the text that you have in the voluminous authorities before you, we respectfully agree, and one can see why he reached that view. So that provides no answer. Finally, on issue 1, so-called domestic constitutional arrangements and their relevance or irrelevance. We are dealing here, bear in mind, with the transfer from colonial status to independence in the case of the ROC, and that involves other, in the setup of the new arrangements on the island of Cyprus, other international participants and lawful, proper international agreements with them and with the newly independent ROC. We are not dealing with mere internal alterations at a factual or legal level. We have no quibble with the basic international law principle that you can't adduce your domestic law with a view to evading your obligations under international law. That isn't part of my case or the logic of my case. But here we are simply not doing that. We're analysing instead whether the body on whose behalf, or in respect of whom, notification was given, has ceased to exist. And for that purpose, there is nothing illegitimate about relying on the various arrangements that affected the change from colonial to independent status, including the arrangements relating to the SBAs and all the other actions on the international plane. We're not using any of that to circumvent obligations under international law. We're simply taking into account those international developments for that purpose, and that we respectfully submit violates no principle. Issues 2 and 3, briefly if I may. The extent of provision that is in fact made for these claimants is dealt with in particular, and Lord Sumption's referred to it already, but it's dealt with in particular in the evidence of Lisa Young. See specifically Appendix 2C, tab 182, 2533, especially perhaps paragraph 14. My Lord Wilson pointed yesterday, my learned friend has come back to it, to the UNHCR letter, which was characterised as saying, well, welfare assistance depends upon residence in the Republic, healthcare depends upon welfare, the labour market depends upon it. You see the force of the point, my Lord will remember it. But it is perhaps worth going to the fiscal officer of the SBAs who gave evidence, Gillian Dean, Appendix 2D, if you would. Tab 223. Again, I'm not going to go through this in any great detail, but it does give you the flavour of what has actually been going on here, which is considerable efforts, considerable attempts to assist these claimants to access proper and appropriate benefits under the regime that is available. So the witness statement starts at 2813 behind 223, and I'd ask you to read that in full at some point, but I wanted to just pick out a couple of documents, if I may. Firstly, 2834. You'll recall, I think, that I went to this document in opening for the email exchanges that run between 2827 and 2833 about whether or not today, that's in 2016-17, they are entitled to enjoy the entitlements provided by the Republic of Cyprus as refugees under their system. Answer, yes. But you get something of a flavour of what has been happening from 2834. This is a meeting between the SBA authorities and the ROC. And just to cast an eye, again, this is more flavour than anything else, but cast an eye over the second and third paragraphs on 2834. There's confirmation of the right to work and no suggestion it's dependent on residence in the Republic. If one goes on, or goes back perhaps to 2823, this is more to do with healthcare.
Where have we gone?
2823, so back in the bundle, sorry to jump around, but we tried to find a labour one and or a work one and a healthcare one, but 2823, that email at the top is at least worth an eye.
very sorry to interrupt. Mr. Eady said this is the lady who gave evidence in the proceedings. This is a witness statement dated June of this year. There's been no application to deduce further evidence. Obviously, my lady will look at it, but I just wanted to correct that.
Well, I'm grateful to my learned friend for that.
There is, in fact, is there not, Mr. Eady, a fortnight later, a witness statement from Ms. Gregory of Lee Day saying all this is very controversial.
It is, and that leads into and feeds into the UNHCR correspondence, which I'm going to come to in a moment. But just so you see the underlying documentation, there's no controversy that these emails existed and were sent. And the position ultimately, to cut this short, the position ultimately is that the position that has been adopted by the claimants throughout, that one sees from the meeting with the UNHCR, or a record of an email referring to the meeting of the UNHCR at 2825 in the first longer paragraph. In effect, they're going to wait for the final position in the UK before engaging or re-engaging with the ROC. But they, in effect, assert that they have an absolute right to move to the UK, and the court must, in principle, shut its eyes to the possibility of them being recognised as refugees by the Republic.
So I don't find that text that you just referred to. 2825.
2825.
This is the one that begins, "Good morning, Olga and Christela."
Yes, I think so. Right, sorry, let's get that again. Yeah, it's in your it's the final sentence of the first big paragraph in the email.
I see.
In your words, there, we'll wait for the final
I'm
position
grateful I missed that.
before re-engaging. And the position that's been taken today by both Mr. Fordham and Mr. Hussain is that none of this really matters. None of the UNHCR correspondence really matters, because in principle, the court should shut its eyes to the possibility of them being recognised as refugees in the Republic and having full-blown access to gold-plated benefits, if that was the position. It matters not on their case, because they say that they have an absolute right to go to the United Kingdom. And our respectful submission in relation to that is that the Cypriot position and the position that's been reached with the Cypriot authorities is plainly of relevance to the satisfaction of the obligations under the Refugee Convention. There are a series of points which make that abundantly clear, and one can analyse it in any number of different ways. If one's simply asking the relevance question, you could say, well, one way of looking at it is that the Republic provide the actual services, the actual access, and we pay, the point I think Lord Reid made and with which we respectfully agree, or you can say that in a situation such as the present, where you have the unique situation that exists within Cyprus and with the SBAs having set up, with the international agreement that has been reached, the constraints that operate on full-blown settlement in the SBAs because of those international agreements, it's inevitable that the delivery of these rights will need to take account of that particular unique setup and that situation. And what that situation has led to, in effect, is the creation of the only civil society that there is in the SBAs, which is the 10,000 or so Cypriots who are living outside the bases. And it's completely unrealistic to try to impose, as it were, onto that unique situation precisely either the interpretation or the spirit approach, it matters not terribly which, that says, well, compare them with the United Kingdom citizens in the UK or compare them with those who are living on the base.
Neither of you or none of you has educated us about international principles of construction and whether there are cases in international law where, for example, the ICJ or other international tribunals have looked at words and say they just need to be adapted or need to bear in mind the particular context? I mean,
My
I
Lord,
suspect there is a rich jurisprudence.
I think there might be, and there's at least one that we could certainly provide to the court, I think, hereafter, if it would be of assistance.
Well, it
where
certainly-
that,
certainly
precisely that sort of approach has been followed.
Because,
But
bearing in mind what happens under the Human Rights Act here, and indeed in the light of European law, one would be surprised if at the international level there wasn't.
well, we'll see if there's anything of that kind, and if we can, and if we may, we'll submit it to the court just as an authority without troubling the court with further submissions. But the reason I emphasise this unique situation and the SIPRIS obligations having relevance, because that's the only way in which these obligations are truly going to be delivered in this unique situation, we respectfully submit that it would be very, very strange if the Hussein-Fordham thesis, which is wrong in principle, were correct. And one of the reasons it would be very, very strange is because that is not the position, as I think my Lord Calmworth pointed out, that the UNHCR have taken. It would have been the easiest thing in the world for them to say, we take the position that it's absolutely irrelevant, all of this. There's no point in troubling us with the detailed mechanics of how the Labour Office works in the Cypriot enclave of this, what, that and the other. Fact of the matter is you can't export the ability to conform to these obligations, and it's fundamentally wrong, and so on. But they haven't done that. They've gone nowhere near that. Their approach throughout has been to try to work through these problems in a sensible, cooperative way, taking account of the unique international legal situation that exists, and that is the position that they've taken. Now, we haven't yet reached, as it were, agreement or anything like it with the UNHCR as to precisely where those practical issues land, but that they are confronting them as practical issues is absolutely plain, that they are not taking the position that this is unacceptable in principle, which is the core of the case that is made against me. I think the court had a bit of an exchange as to whether or not in that correspondence with the UNHCR they had ever got to the position of saying, we now think, as a matter of practicality, that the only thing is to send these individuals or to allow them to go to the UK. They have not got to that position, even in practice. And I'm afraid the correspondence is a bit all over the bundles. But
Article 32 of the Vienna Convention appears to require treaties to be interpreted with a view to avoiding a result which is either manifestly absurd or unreasonable. That may be the principle which Lord Mance had in mind.
My Lord, yes, I suspect he had in mind actual cases.
There's a good deal of case law on this as well.
Can I just collect together for you, if only in a group of references?
You better give us the
I'm going to give you the references to the UNHCR correspondence. You have it in a block. 30th of September 2013, core bundle 2B, Appendix 2B. Yeah, Appendix 2B for Bertie, tab 157, page 1649.
1649.
1649. That's the September letter, and that said they're concerned. Didn't say anything about we've got to send them to the UK. Responded to by the Home Office, 25th of November 2014. It's taken a jolly long time to get back to them. Core Volume 3, tab 42, 1160. That then created something of a hiatus, and the next correspondence appears to have picked up again in June of this year, 16th of June from the United Nations, 2D this time, D for Daddy, tab 224, 2870. And that, I think, is the closest they come to saying humanitarian concerns outlined above, lack of alternative durable solution. We would deeply appreciate an exceptional humanitarian gesture that would admit these refugees to the UK. It's not been put on the basis of right or collapse. Exceptional humanitarian gesture. That's the closest they come. Next, Home Office, 6th of July, responding to that, 2D, tab 228, page 2905. That's the long letter. And that's...
Sorry, what was the reference again? 2905?
2905,
Right.
2D, tab 228. Then I think there's a letter from the another letter from the Minister of State, the Home Office, 2D tab 229 at page 2909, and then that leads to the latest letter from the UNHCR, to which we haven't fully responded yet, Core Volume 1, page 299, at Annex C to my learned friend's case. So that's where all that collection of references sits. But as I say, they have not taken the position that this is wrong in principle, and the closest they've come to it is exceptional humanitarian gesture. That leaves the specific articles. Those are the overarching points I wanted to make in relation to the articles. But in relation to the specific articles, just to give you a couple of submissions, if I may, in relation perhaps to each. Article 26, which you will recall, if you want it, it's in Core Volume 3, tab 24, at page 906. My learned friend says, well, they come within the rider, in which case, fantastic, but we thought he was relying on this to establish a freedom of movement. If he's not, well, so be it. Article 6 doesn't apply, even on his case, because you're within the rider. The question remains what territory means, and our big point in relation to territory, as you will recall, is that it would be a very large decision indeed to conclude that territory in the context of these articles means metropolitan UK and all overseas territories. That is a very big decision, because it would mean that your appropriate comparator for the purpose of lots of these articles is the best placed person or the alien or whoever else it may be, anywhere, presumably on his case. If you can find someone in Cayman who's treated fantastically well, an alien in Cayman who's treated fantastically well, you just rely on that. You take the best you can, you head to the top, and then you say, well, that's me, that's the alien against whom I'm comparing myself, and there you are. But that's a very big point, and we respectfully submit isn't the right approach to these articles. The right approach is to recognise that territory in the context of these articles, consistently with Article 40 and its recognition that overseas territories have their own interests, their own social conditions, you can make your own reservations in relation to overseas territories, you treat these substantive articles and the word territory within them as meaning, in our context, the SBAs. So that's Article 26. Article 23, public relief, that hasn't been subject, if the judgments and arguments set out below are anything to go by, of any full-blown or extended argument other than references amongst a group of other articles or exposition by the courts below. And it's very difficult to try to deal with assertions of this kind with the potential complexities that they raise at this level. But the position in relation to Article 23, it might be thought, when applied to the SBAs, is either that you compare with British citizens in the SBAs, in which case they get nothing, because there is no social security system of that kind operating in the SBAs, or you take a flexible and sensible and purposive approach to the concept of nationals and the existence of the civil society in the SBAs, and you say, well, properly that is to be construed as meaning, in our context, where the only civil society is the 10,000 or so Cypriots, that is the comparator. And on that basis, they get, and they should get, the same social assistance as is available to Cypriots. But so the alternative that my learned friend contends for doesn't deliver gold for him, it delivers nothing. But the punchline of all of these, or lots of these articles, which we respectfully invite the court to note, is not that it is impossible to deliver them. Even on my learned friend's case, it isn't impossible to deliver them. More money might, on his argument, have to be provided and so on, but it's not impossibility. And so it doesn't lead, reliance on these articles and the allegations of breach still don't lead to a punchline that he wants, which is, therefore, you have to admit me, and allow me to reside in the United Kingdom. So that's the position in relation to Article 23. Housing and Article 21 as favourable as possible. But again, most of these rights are, as you appreciate, equal treatment rights in nature. They are not, unlike some of the positive obligations imposed on the state under the ECHR, positive obligations to provide a house or a particular level of social security to keep you above Article 3 or to keep your children in clothes and so on. They are equal treatment rights. And so housing is of that ilk. And again, if one says, well, what right to housing would aliens or nationals in the SPAs have, the strict answer is none, because that system doesn't exist. But the reality is, and this is the way that everyone has been operating, both the SPA authorities and the Cypriot authorities as well, such housing as the SPAs could reasonably provide, or housing in Cyprus if that's the better option. And so we respectfully submit that that article doesn't lead to impossibility either. And I've made my submissions in relation to Article 34 and assimilation. The only way in which that is deliverable in the unique situation in the SPAs is assimilation into the civil society, and the only civil society that exists there. And there isn't a fundamental legal impediment to that of the kind that the Court of Appeal considered there to be. Their reasoning was, as my Lord Reid rightly pointed out, that there was some fundamental principled objection to assimilation by reason of the Treaty of Establishment. But the answer to that is that the MOU and the arrangements that have been made with the Republic of Cyprus make it entirely clear that they are content, as it were, for there to be that sort of assimilation. It's no good my learned friend saying, well, there's the preamble to the MOU. There indeed is the preamble to the MOU, but the fact is that the MOU then provides the rights to these refugees of the same kind that they would receive if they were in Cyprus. And so we respectfully submit that that point goes nowhere either. My lady, I'm sorry, I see your papers are packed and you're ready to head for Christmas.
I packed them up at the moment that you'd reached your time limit, Mr. Eady.
I'm sorry.
But that was the only sensible thing to do.
Then the last few minutes may have been wasted, for which I apologise.
No, I was still listening. That's a different matter. Well, we're grateful to you all, of course, for the very full submissions that we've received in this very anxious case. And we will now go away and try and work out what the answers are. And in the meantime, we will wish you all compliments of the season.